Hold up, grab my soda cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape paint. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimation. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dogs at homes, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over this bit, non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions.
And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button. There's a PayPal link down there for anybody who wants to share some love. All those appreciated. And for those that don't know, we've been recently going through what's called a forcible entry and detainer, more commonly known as eviction. And of course, it's a wrongful eviction. So we're having to fight it through this procedural legal process. And various different things along the way, showing that people don't operate in good faith, or they don't know their job, or they're incompetent, whatever. And so the last thing I filed was a a motion to enlarge findings, request for judgment on the merits, and request for production of documents, because the magistrate said that at the hearing that they would take it under advisement and they would get back to us within a week or so. And within that week, we came upon the opportunity to go ahead and move. And because of the hostile environment and the harassment, we did take upon that opportunity the very next day. We got the notice on February 1st. So on February 2nd, we went ahead and moved. Well, then the plaintiff, the management company, S.W.A.P, entered a dismissal into the court. And that leaves us without an open record with the judgment from the magistrate, whether it be dismissed or granted. And so we filed that motion to open it back up to get that judgment, and it was then denied. They accepted our filing, but then they turned around the very next day and denied it. So we're going to go over that information and point out another procedural legal error as it relates to the court this time, because the denial did not come from Patrice Eichmann, the magistrate that presided over the hearing. Instead, it was denied by another gentleman another magistrate when he's not the one that has the authority to do that. It has to go back to the presiding judge. And so we have a procedural legal error that we're going to point out and address that. So let me pull up my information here. Got to switch screens here real quick. Oops. Okay, let's see here. Can we make that larger? That's kind of hard for you guys to see, so let's do this. There we go. You guys should be able to see that pretty well now. So what we've got is in the Iowa District Court for Blackhawk County. Now, this is after the denial by a judge that was not presiding over the case. So we're going to address that in a next one, which is in the Iowa District Court for Blackhawk County, the case number and everything, renewed motion to vacate and for findings based on the law of the case. It's the same thing. The law of the case is the findings of facts and conclusion of law. It's called the law of the case. And again, like I said, the presiding judge is the one that was there and witnessed that the plaintiff admitted that she's been doing this for 8 years, that she did not give a 7-day notice to cure, and that she did not know that was a strict statutory duty to do so. And so therefore the law of the case is that in an equitable action, that one point alone proves that the plaintiff was seeking equity with unclean hands. In other words, she was actually in violation of statutory code. And then after receiving a notice from us for a noise complaint, did nothing about it. And that was her breach. So then it escalated. And now she's trying to hold me accountable in these courts as if though I'm the one that breached the contract, when in fact she was the one that did so. And it says, comes now the defendant, Keith Little and Joyce Schmidt, pro se, and moves the court to vacate the denial of the motion to enlarge. Defendant asserts that the law of the case, established through the plaintiff's own admissions during a hearing, necessitates a formal finding of unclean hands and bad faith. And again, it's just the presiding judge, that presiding magistrate that heard the case that can do that. The admissions constitute the law of the case. Strict statutory duty. At the hearing on 1/26/2026, the plaintiff's manager admitted under oath that they failed to issue the mandatory 7-day notice to cure, Iowa Code 562A.271. Ignorance is no excuse. The manager further admitted to being unaware of this statutory requirement. Under long-standing Iowa precedent, ignorance of the law by professional property management entity is no excuse and constitutes per se bad faith. Unclean hands. These admissions establish as a matter of law that the plaintiff entered this court with unclean hands. They sought the equitable remedy of eviction while simultaneously violating the very statutes that govern their profession. Statutory presumption of retaliation. Pursuant to Iowa Code 562A.362, if a tenant makes a good faith complaint, that was our noise complaint, to a governmental agency such as the Waterloo Building Department or the landlord property manager directly regarding health, safety, or habitability, such as the noise and dementia crisis, any subsequent attempt by the landlord to recover possession within 1 year creates a legal presumption of retaliation. And what that does is it flips the coin. It puts the burden of proof on them that they now have to prove that they were not retaliating because of my noise complaint. Evidence of a good faith complaint within 1 year prior to the alleged act of retaliation creates a presumption that the landlord's conduct was in retaliation. Pattern of practice and public safety. Warning of future victims. The plaintiff's admitted ignorance is not an isolated error, but a pattern of practice. She testified that she's been doing this for 8 years and still did not know her statutory requirement to issue the 7-day notice to cure, did not do so in this case, and I'm begging to question whether she's ever done so, if she's ever issued a 7-day notice to cure. Testimony established that MGT managed the property for a 19-day period, December 1st to December 19th, before fulfilling the legal requirement to register the unit with the city of Waterloo. So she didn't fulfill the legal requirement under city ordinance. She didn't fulfill the state statutory requirement for 7-day notice to cure. And so we're going to ask for production of documents to see if she's fulfilling all the rest of her duties, because if it shows that she's not, it shows a definite pattern of practice. And if that pattern of practice isn't stopped, then we have no prevention of harm. To dismiss this case without a finding of fact regarding these admissions allows the plaintiff to shield their illegal practice from public record. So what they're trying to do is, well, whether they're trying to do it or not, the effect is that they are essentially hiding the record and preventing the public and their right to know. This is a First Amendment issue, folks. The public has a right to know if the people that they're renting from has a bad property manager. And if 8 years of evictions and nobody's been able to pull that out, and they still dismiss it and hide that fact, that is not prevention. That is, in fact, allowing them to continue in the usual ordinary course of business with unclean hands. A judgment on the merits is necessary to protect future low-income and disabled victims from a manager who operates outside the bounds of law. Procedural denial of justice. The record speaks. The record of the hearing is immutable. A magistrate who did not preside over the hearing cannot summarily deny a motion to record these admissions. Such a denial is a denial of justice because it suppresses the law of the case that was established under oath. So again, this woman under oath established that she'd been doing this for 8 years, did not know she had a statutory duty, and thus did not follow the statutory duty. As a pro se litigant, I am entitled to the court's neutral application of mandatory statutory protections. Iowa Code 562A.36 creates a presumption of retaliation that arises by operation of law when a tenant makes a good faith complaint. Even though I did not use the formal legal term of art during the hearing, the facts in the record, specifically my December 16th noise complaint and January 5th request for accommodation, followed by a January 12th lawsuit. So the complaint and the request for accommodation both within a month, less than a month, not a year, but less than a month, placed a mandatory duty on the court, not anyone else, but the court, to presume retaliation. By dismissing the case without addressing this presumption, the court has allowed the plaintiff to bypass a statutory bar to their action. Again, he who seeks equity must come with clean hands. She stated on the record she did not have clean hands. Therefore, the court cannot give her the forcible entry and detain her. When we were forced to move because of the hazardous environment and harassment continuing, They issued the plaintiff issued a dismissal on their own. That's not based on the merits. That is, in fact, again, them denying their obligation, their duty, evading the transparency and accountability that they're supposed to be upheld to, resulting in denial of justice and a violation of my due process. And it should be our, but that's inconsequential at the moment. Wherefore, defendant respectfully requests the court vacate the previous denial and enter a judgment on the merits, reflecting the plaintiff's admitted breach of statutory duty and their lack of standing due to unclean hands. February 6, 2026, respectfully admitted, Keith Littlejoy Schmidt. At note, address change. The legal bar to entry is unclean hands. Listy Wickham used an equitable action and admitted on the record that she failed the strict statutory obligation of issuing and that should be duty, 7-day notice to cure upon the defendant's noise complaint. This leads us to believe a fair housing investigation should be had as it relates to Americans with Disabilities Act and violations all along jurisdictions relevant to other Americans who have a right to know and a right to cure themselves, who may have been previously violated in similar manner, and those in possible future. So that's just our notice for renewed motion to vacate and for findings based on the law of the case. But in the meantime, that may be the way they want to try to hold it, but remember, forcible entry and detainer is an equitable action, and therefore they must consider the common law, which is not administrative. Again, this is why I'm pointing out it's a procedural legal error. They can't just go by their administrative duties. They have judicial duties and superior, equitable resolutions that are at hand, and they must seek those. Again, it's their obligation, not mine. I'm just pointing out their obligations and what they're doing wrong. I'm not making accusations. I'm just pointing out the errors of procedural the procedural legal errors. So you do realize that it is an administrative hearing, not judicial. Focus on the contractual elements that give them standing. And that's what I did. Pointed out that they came with unclean hands. In other words, they had a strict statutory duty to follow the performance that they were contracted under, which is maintenance. And a noise complaint is a maintenance issue. No, they are not. They are not administrative. They like to play them as administrative, but they are, in fact, judicial because of the equity element. Equity is merged with common law. There must be a judicial judgment handed down. So anyway, along with that, we understand that they're giving they're operating or performing in procedural legal errors on both sides. Listy Wickman, the attorney, the magistrates. I can't just single it out as one magistrate anymore because there are several, just like I said in my case 5 years ago or 10 years ago. There were 5 different magistrates that dealt with the case. So I'm quite familiar with this, and I'm prepared to continue moving. And that movement is a matter of noticing other public departments and organizations as it relates to this case. So we're going to go over those documents next. And what we're doing here is giving these guys the opportunity to correct their procedural legal error. And if they don't, then we appeal the dismissal to the district court and enter in our claim for a civil suit at the same time. So we're going to give everybody notices. That's what we're going to go over next. So let's take a look. Yep, that's that one. That's the first one. I was up all night drawing these up. Notice to retain and preserve evidence. It's a litigation hold because we're going to be suing them. Sent via certified mail and email. Oops. We kind of got redundant there, didn't we? I don't know how that happened. We can fix that later. Anyway, the two management property or MGT Property Management Company, attention Liskey Wickham. The address dated February 7th. Like I said, I was up till 4:35 o'clock this morning doing this shit. Notice of anticipated civil rights litigation. Keith Little and Joyce Schmidt. Please be advised that this letter serves as a formal notice to retain and preserve evidence. You are hereby instructed to preserve all documents, communication records, and electronically stored information that are relevant to the tenancy of Keith Little and Joyce Schmidt and the subsequent forcible entry and detainer action. Case number, This request specifically includes, but is not limited to, internal communications, all emails, text messages, internal memos regarding noise complaints, requests for reasonable accommodation, and the decision to initiate eviction proceedings. Licensure and registration records, all documents related to MGT's professional licensure and registration history of 1334 Meadow Lane with the City of Waterloo, specifically covering the period of December 1st, 2025 to present. Tenant ledger and phone logs, detailed logs of all interactions with the defendant, including notes made by staff during or after phone calls or in-person visits. Property management agreements, the contract between the property owner and MGT Property Management for the period starting December 1st, 2025. And that's going to come in regards to the notice with intent to sue, because as a property manager, they are the trustee, the obligee, and they have an obligation to their principal, who happens to be the property owner. Duty to suspend routine deletion. You must immediately suspend any automatic deletion, overwriting, or recycling of electronic data, such as auto-deleting emails or overwriting server backups. Failure to comply with this preservation request may result in a spoliation interference in Iowa District Court, where the jury may be instructed to assume the destroyed evidence was unfavorable to you. And this is State versus Langlet. You can look that one up, State versus Langlet. Tell you all about the spoliation. All materials must be maintained, and that's a good one to use when they take your phone and delete information from your phone, videos and text and stuff from your phone. Oh yeah, that's a spoliation, and that's because they deleted. That's State versus Langlet. All materials must be maintained securely to prevent alteration or destruction until this matter is fully resolved. And then I give them the contact name and contact information. So that's the notice to retain and preserve evidence. The next one is notice of intent to file suit for civil rights violations to MGT Property Management, 30-something Real Estate LLC. February 7th, 2026. Demand $250,000 now. You want to keep making me work for this? You want to keep delaying, denying, and trying to sell justice? It's going to cost you. Yes, the matter may be judicial, but the court handling it is administrative. But in that administrative duty, they also have the superior duty to be judicious about things. They must be judicious. In other words, fair. See, equity is an ancient English judicial system. That's why I say you cannot separate judicial from equity. When you enter an equitable action, they must go on the bearings of the judicial discernment. And the judicial discernment here is coming with unclean hands, pure and simple. There is no value in it. And yet they're giving value to the plaintiff with unclean hands. And so, yeah, good loud. We started at 25,000. They should have settled. We went to 100,000 when they took us to court. They should have settled. They're denying it on both sides. They should settle. We're still willing to settle. We're still giving them grace. We're still doing our next right thing. They're still denying their transparency and accountability. Please take notice that Keith Little and Joy Schmidt, claimants, intends to file a civil action in the Iowa District Court seeking damages in the amount of $250,000 for violations of the Iowa Civil Rights Act and Fair Housing Act. Strict liability basis for the claim, strict liability for statutory breach. Your admission of failing to provide a 7-day notice while knowing a tenant's disability constitutes willful and wanton disregard for the rights of others. Unlicensed activity. Operating an unregistered rental unit for 19 days while ignoring strict statutory duties constitutes consumer fraud, violations of the Fair Housing Act, and Americans with Disabilities Act. Transfer trauma or relocation stress syndrome in relation to my companion who has frontal temporal dementia. The illegal eviction process caused irreparable medical harm to a disabled senior. And all psychologists and medical doctors will agree with this. It is known scientifically. Legal precedent for damages. Estate of Willis versus Sutter Village, 2025, establishing 6-figure awards for failure to accommodate disabled tenants during maintenance crisis. Waterman versus Landlord, Iowa Supreme Court, affirmed that actual damages under Iowa Civil Rights Act include emotional distress, which can be significant in housing cases involving vulnerable populations. Feidler Law Firm, 2025 jury verdict. An Iowa jury recently awarded $2 million in emotional distress and $8 million in punitive damages in a landmark housing harassment case, proving that Iowa juries will not tolerate a landlord's abuse of power. I'm telling you, $250,000, they should settle. They should settle. I think we've been fair and reasonable in our grace all along. And if they keep pushing it, that amount is just going to keep going up. They should have settled long ago. We're very humble people and would have been very happy with a settlement of $25,000 or out of court settlement of maybe half. But here we are a month later, and we're still dealing with it. That's 2 months. 2 months now, plus the initial time that we spent with the upstairs tenant a couple weeks. So 2.5 months now we've been dealing with this, and nobody's come forth with with any kind of responsibility or accountability. None. Opportunity to cure. Claimant will withhold filing this action for 14 days to allow you to engage in a good faith settlement discussion to make the victim whole. If no response is received, we will proceed with the IOCR right to sue. That's the Iowa Office on Civil Rights right to sue process and seek the full $250,000 plus court costs. And again, names, contact information. So that one there, we got 30-something real estate involved. See, now it's going to be up to them because they're the ones that are actually liable. Okay? They're the principal. So they're the ones that are supposed to be making sure that Listy Wickham is functioning in her property management capacity in accordance with the law. And if they don't, then it's on them. So again, I'm pretty sure Listy Wickham is going to lose her job one way or another. I don't really care, other than the fact that I'm merely trying to prevent this from happening in the future by using my right to know and get it out there on public, and right to make a record so you know. See, exponentially, your right to know is greater than my right to express it. So the next one, This one's going to the Waterloo Commission on Human Rights, the Iowa Office of Civil Rights, or Waterloo Commission on Human Rights. So we're going to send this to the local Waterloo Commission on Human Rights. Notice of statutory retaliation and systemic bad faith. Pursuant to Iowa Code 628.36, a legal presumption of retaliation exists in this matter. Hold on, folks. On the 5th of January, 2026, by email and personally served by hand through a third party. On the 6th of January, 2026, the defendant issued a good faith request for reasonable accommodation regarding a dementia-related medical crisis. Within weeks of this protected activity, MGT Property Management initiated eviction proceedings. Under Iowa law, because this action occurred within 1 year of the complaint, the burden of proof shifts to the landlord to prove their actions were not retaliatory. They've done nothing of the sort. Evidence of unclean hands and illegal operation. The plaintiff's pattern of practice demonstrates a willful disregard for both state and local law. The 19-day registration gap. Testimony at trial established that MGT management began managing the property on December 1st, yet failed to register the unit with the city of Waterloo until December 19th. Under Waterloo City Code 9-7-5A, it is a violation of law to allow a unit to be occupied without registration. Breach of strict statutory duty. MGT admitted under oath that they failed to issue the mandatory 7-day notice to cure, and further admitted to being unaware of the law. Ignorance of the law is no excuse for a professional management entity. Denial of justice and the right to know. The plaintiff sought a voluntary dismissal only after the defendant was forced to provide his own cure, which was relocation under the duress of an illegal lawsuit. A dismissal without a judgment on the merits is a denial of justice. It allows a bad faith actor to shield their lack of licensure and statutory breaches from the public record, thereby endangering future low-income and disabled victims. Conclusion. Defendant asserts a First Amendment right to know and a right to a transparent judicial record. We request that the Commission investigate MGT Property Management for systemic violations of the Iowa Civil Rights Act and the Fair Housing Act, using the court record as an admission of their failure to perform mandatory duties. Again, name and information, contact information. Then we've also got the Iowa Real Estate Commission formal complaint. Because they were, in fact, operating as a property management. Oops. What's going on here? There we go. That's what we just did. Tribe. That's what a civil rights lawsuit is. It's a tort claim. Okay? We're giving them notice. We're going to file a civil rights lawsuit. They've injured us in equity. That's a tort claim. And they did so by their breach of duty, their performance obligation under that maintenance of a lease agreement. You're just using different words, brother. So here we have the Iowa Real Estate Commission formal complaint. And this is because we did, in fact, find out that they were not registered from the 1st to the 19th. That means that they were managing a property, even if they have a real estate license. That means under that licensure, they were still operating illegally during that period of time. Okay? And if we find out that they don't have a license, that ups the game. And that $250,000 now has a lot of smack to it. Okay? Again, because it's the 30-something real estate LLC in that previous notice. Something real estate LLC. Okay. So the Iowa Real Estate Commission formal complaint. A complaint against management company, unlicensed activity and bad faith practices, parties and jurisdiction. I am filing this complaint against MGT Property Management Company, address 224 Byron Avenue, Waterloo, Iowa. This complaint concerns violations of Iowa Code Chapter 543B and Iowa Administrative Code 193E, specifically regarding professional conduct, licensure transparency, and the legal capacity to perform property management services. Statement of facts and pattern of practice. We're going to reiterate, it's a pattern of practice. The 19-day registration gap. Testimony in case number SC 200-826 established that the respondent began managing the property located at 1334 Meadow Lane on December 1st, 2025. However, records from the city of Waterloo confirm they did not legally register as the manager until December 19th, 2025. That is, in fact, a violation, again, of their licensure, while they've already admitted that they violated the strict statutory duty to give proper notice, and they violated the Americans with Disability Act by not addressing the request for reasonable accommodations in relations to an American with disabilities. So we have a definite pattern of practice. Unlicensed activity. During this 19-day period, the respondent performed regulated real estate activities, including ignoring their strict statutory duty to issue a 7-day notice to cure to the upstairs tenant for a noise complaint without valid standing under Waterloo City Code 9-7-5A. Breach of statutory duty. The respondent's manager admitted under oath to being unaware of the mandatory 7-day notice to cure, and professional property managers are held to a standard of strict statutory duty. Admitted ignorance of the law constitutes a failure of professional competency. Failure of accommodation. The respondent further willfully ignored a request for reasonable accommodation for a tenant with dementia on the 5th of January, 2026, opting instead to pursue an illegal eviction in violation of the Civil Rights Act, and then admitting on the stand that they came with unclean hands. Request for investigation. I request that the IREC investigate MGT Property Management for engaging in property management services while the unit was not legally registered, failing to demonstrate professional competency regarding Iowa landlord-tenant law, and operating with unclean hands by using the judicial system to bypass civil rights protections. Conclusion. A dismissal in small claims court does not absolve a licensee of their professional duties. I am requesting a judgment on the merits regarding their professional standing to protect future low-income and disabled tenants from similar patterns of practice, not just by Listy Wickham, but by any property manager that would do so. See, I'm on your side, folks. I do this for us because we're in the moment of it. But I do this for you guys. Again, that First Amendment is imperative to comprehend in all of its aspects. I have a great right to speak and express myself. But you people exponentially have a greater right to know. Okay? This is the thing about observing something, contemplating it, and then being able to establish that record. We established that record, and they're trying to hide it. That's a First Amendment violation. Okay? The next one, like I said, we're putting this stuff out. Iowa Chapter 22 public records request. See, I did call the city clerk, and I did ask him about that rental registration history, and they told me they weren't registered until the 19th. So now we're going to make a formal request because my call on the phone was informal. Now I'm going to make a formal request, open records request, rental registration history, 1334 Meadow Lane, Apartment D, Waterloo, Iowa, 50701. Dear City Clerk, pursuant to the Iowa Open Records Law, Iowa Code Chapter 22, I am requesting the following public records related to the rental property located at, and then put in the address. This is one that I don't have printed up yet, but going to do that today here after I'm done. The application timestamp, the exact date and time the rental unit registration permit application was submitted by MGT Property Management Company for the current period, December 2025 through 2026. Payment records, documentation showing the date the registration fee was paid for this property by MGT Property Management Company. Entity name, 1. Confirmation of the specific entity name listed as responsible local agent or property manager on the registration. Should be MGT Property Management Company. 2. Confirmation of the specific entity name listed as owner of this specific property being managed by MGT Property Management Company. And it should be 30-something LLC, 30-something Real Estate LLC. That's what I found. It might be different. The records I saw said 30-something Real Estate LLC. So we're going to request that formally to make sure we know what we're talking about so that we can give the proper notice to the proper property owner as it relates to notice to file suit. Registration status on December 1st, 2025. Any records indicating whether this property held a valid active registration permit between December 1st, 2025 and December 19th, 2025. And the reason it's worded that way, any record indicating whether this property held a valid active registration permit, because it's the property that's registered, not the property manager. So the old property manager might have a rental registration that was still effective, but that's not transferable to a new property manager. That's why they have to re-register it in their name. So if they try to use that, we're going to have that record pulled, and it's going to show us. It should show us that if that old registration was still valid under the old property manager, but they're no longer managing it. That's why you're required to register it in your name, listy. Public interest and fee waiver. This request is made in the interest of public safety and transparency regarding the enforcement of Waterloo City Code 9-7-5A. I am a former tenant with a pending civil rights matter. Therefore, I request a waiver of any fees. If fees are expected to exceed $10, please notify me in advance. I request these records be provided in electronic format to wordwizard@wordwisewarriors.art and physical documentation mailed to the following address. And then I give them my name and contact. The next one here is just a chain of timeline notice. It's just keeping things in a time format so that certain people have it, so that when it gets presented into the civil rights court, they'll already be apprised of, what it all is. And so I'm going to go through and read this. This is the timeline of the events as they happened. And this timeline connects their illegal period of operation directly to their failure to accommodate our disability. The defendants have records of the following. Early December, we attempted private reconciliation with the upstairs tenant pursuant to Matthew 18, verse 15. The tenant refused to provide a cure or de-escalate. December 1st through 15th, the situation escalated as a person with dementia, my wife, the environmental hazard, noise harassment caused a flight or fight response, leading to verbal outbursts and a desperate attempt to signal for help. December 16th, after escalation, I don't want to be this escalated, angry old man. So I went to Matthew 18, verses 16 and 17, where I take it to a second witness, which is Listy Wickham, the property management. We formally notified MGT Property Management of the upstairs tenant's harassment. Note, on this date, MGT was managing the property illegally, unregistered with the city of Waterloo. The unclean hands fact. On this date, MGT was managing the property illegally per Waterloo City Code 9-7-5A. No manager shall allow a unit to be occupied without first registering it. December 19th, 2025. MGT finally registers the property. This confirms they were operating as unlicensed actor for the first 19 days of the month. December 23rd, neighbor in apartment C complained of the noise escalation, noting that myself and the upstairs tenant were getting loud with each other. December 24th, neighbor in apartment B called Waterloo police. Police investigated and recognized the situation as a medical civil distress issue, making no service notes. December 29th, the upstairs tenant, the aggressor, complained to MGT. MGT immediately accepted this hearsay, ignoring our prior notice and the police visit. Phase 3, the bad faith eviction. I don't know why that's in there. The bad faith eviction, January 2nd, 2026, Listy Wickham, MGT, issued a 3-day notice to quit. Legal error. MGT bypassed the mandatory 7-day notice to cure. She never gave the upstairs tenant a notice to cure. She never gave me a 7-day notice to cure. She went straight to a 3-day notice to quit based on his hearsay, a video that he took after it was escalated, and she ignored the original causation. January 5th, we personally served MGT with a request for reasonable accommodation by email and certified personal service. MGT willfully ignored this, violating the Iowa Civil Rights Act. MGT filed a small claims forcible entry and detainer suit on January 12th. January 26th, hearing was held. Magistrate took it under advisement. January 28th, we filed a supplemental memorandum of law and request for production of documents as it relates to the registration and the licensure and all the other stuff, bonding, insurance. February 1st, trapped in a hazardous environment with no help from MGT, we found a new home. They contacted us February 1st, and we said, yeah, we'll move in tomorrow. February 2nd, we moved for our survival because of the constructive eviction. February 2nd in the afternoon, MGT dismissed the case to avoid a ruling on their 19-day registration gap and their strict statutory breaches. See, it was dismissed by MGT, not the magistrate. So it took the magistrate out of the loop and said, okay, we're just going to dismiss it because he moved. No, that doesn't qualify it. That doesn't qualify that you won. We moved because we were trapped. We were forced to because of the constructive eviction. Statement of the trap. The defendant was placed in an impossible trap. We followed the law. The neighbors followed the law. And we even followed the biblical principle of private notice. The only parties who remained silent were the property managers, who waited until the defendant reached a breaking point to use the court system as a weapon by dismissing the case only after we were forced to move. MGT is attempting to hide a pattern of practice that exploits the disabled. This is a clear denial of justice and a violation of our First Amendment right to a transparent record. The record indicates that Cooley dismissed the case on the 2nd of February, 2026. This is a procedural legal error in that the presiding magistrate did not consider it. To have another magistrate not familiar with the case dismiss it is a denial of justice and is a shield to transparency which the plaintiff is trying to evade. So we have Patrice Eichmann, who did the hearing. We have Cooley that dismissed it on 2nd of February. And then we filed a motion to enlarge findings and request judgment on merits and production of documents on the 5th of February, 2026. This motion was denied by Abbott Andrew C. on the 6th of February, 2026. This again is the same procedural legal error in that the presiding magistrate, which was taking the case under advisement, is the only one with legal standing to deny such a request on the merits or law of the case. And again, this would be a denial of justice. Denial of justice statement. When a magistrate dismisses a case without recording these findings, they are effectively suppressing a statutory presumption. A dismissal without a judgment on the merits constitutes a denial of justice because it allows a landlord to bypass, in this case, the property manager, the 1-year presumption of retaliation established by Iowa Code 5628.36. And by granting a dismissal after the defendant was forced to self-cure through relocation, the court permits the plaintiff to escape the legal consequences of its admitted bad faith conduct and its unclean hands, thereby leaving the victim without a record for a subsequent civil rights claim. So what we have here, folks, is a failure to communicate. And it is a First Amendment issue. So as I said, I'll keep everybody up to date. That's what we've got for now. That's what I spent up all night making up documents for. Interrupting my unpacking and settling in and spending time with my companion. So that's what I'm off to do. Get back to work. You guys know me. I love you, but I don't give a rat's ass whether you love me back. That part's on you. So enjoy the outro as we remember the birds. Freedom Flame burns on. It's a tribute to Paul Revere.
The pines where the red clay cries, a preacher's words cut through the lies. With a Bible worn and a rifle tight, we march where the tyrant's shadow bites. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn. From dust and blood, a new dawn's born. Oh, 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 oh. The widow sows seeds in her husband's field. Her tears baptize the ground they'll yield. A soldier's ghost hums an old hymn's tune. We'll cross that river for the blood dark moon. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the the truth be sworn from dust and blood. A new dawn's born. When the thunder roars and the levee breaks, we'll plant our flag where the desperate shakes. Through fire and flood, we'll hold the line. For peace ain't bought lest we dare to climb. Oh, freedom's flame burns through the night. A rebel yell for the righteous fight. Break the chains, let the truth be sworn from dust and blood. A new dawn's born.
Man up, slaves, and hit those buttons, or I'll send ice.